Assalamualaikum warahmatullahi wabarakatuh. Good morning, everyone. This is Group 2 of the Human Resource Management Study, and today in this session, we will be talking about the legal environment, or in the book, providing equal employment opportunity and a safe workplace. But first, we want to introduce ourselves. My name is Fallon Afif. Student ID is 2511011021. Our topics for today, which are regulation of human resource management, equal employment opportunity, the government's role, the business's role, the Occupational Safety and Health Act, and employer sponsored safety and health programs. The first half, from 1 to 3, will be covered by me, Falen. The second half, from 4 to 6, will be covered by Aditya. First is about the regulation of human resource management. The regulation of human resource management refers to the laws and government policies that shape how organizations manage employees. These regulations are designed to protect workers from unfair treatment, unsafe working conditions, and discrimination, while also defining employer responsibilities in areas such as hiring, compensation, employee safety, and termination. By following these regulations, companies not only reduce legal risk, but also create a more ethical, inclusive, and safe work environment that supports employee well-being and organizational effectiveness. Second is about equal employment opportunity, which consists of three subtopics, which are constitutional amendments, legislation, and executive orders. First is about constitutional amendments. Constitutional amendments provide the original legal foundation for equal employment opportunity in the United States. Although they were not written specifically for employment issues, they establish fundamental rights such as equality and freedom from discrimination. These amendments limit how governments treat individuals and have strongly influenced later employment laws and court decisions related to workplace fairness. The amendment in USA guarantees equal protection under the law, forming the basis for anti-discrimination principles. These amendments mainly restrict government actions, not private employers, but they later inspired later employment discrimination laws and policies. Next is about legislation. Legislation is the primary way equal employment opportunity is enforced in the workplace. Congress passes specific laws to protect employees and job applicants from discrimination based on personal characteristics. These laws apply directly to employers and require fair treatment in hiring, promotion, compensation, training, and termination. In the United States, Title VII of the Civil Rights Act in 1964 prohibits discrimination based on race, color, religion, gender, or national origin. The Age Discrimination in Employment Act, or ADEA, protects workers aged 40 and older. The Equal Pay Act requires equal pay for equal work regardless of gender. And finally, these laws apply to private employers, government employers, and labor unions. Finally, executive orders. Executive orders are directives issued by the President that apply mainly to federal agencies and organizations doing business with the federal government. In the area of equal employment opportunity, executive orders are especially important because they introduce and strengthen affirmative action requirements to promote workplace diversity and prevent discrimination. Executive orders apply to federal contractors and subcontractors. Later executive orders expanded protections to include women, minorities, and veterans. And finally, employers must create affirmative action plans and document compliance. The third is about the government's role, which consists of two topics, which are Equal Employment Opportunity Commissions and Office of Federal Contract Compliance programs. First is about the Equal Employment Opportunity Commission, or EEOC, which is about the primary federal agency that enforces laws prohibiting workplace discrimination. It investigates complaints, seeks to resolve disputes, and may pursue legal action to ensure equal employment opportunity. Through enforcement and education, the EEOC helps promote fairness and consistency in employment practices. It's about the EEOC investigates complaints and determines whether discrimination has likely occurred. If discrimination is found, the EEOC attempts conciliation between the employee and employer to avoid lawsuits. The EEOC issued guidelines that courts often rely on when interpreting discrimination laws. Finally, the Office of Federal Contract Compliance Programs, or OFCCP, which assures that federal contractors comply with equal employment opportunity and affirmative action requirements. It proactively audits employers and enforces executive orders tied to federal contracts. Its roles encourages contractors to take active steps towards equal opportunity, not just avoid discrimination. The OFCCP enforces executive orders related to equal employment opportunity. It applies to federal contractors and subcontractors with contracts over specified dollars amounts. And the OFCCP conducts audits and on-site evaluation to assess compliance. The second half of this topic, the presentation, will be led by Aditya.
Next, we discuss about businesses' role in human resource management. Businesses play an important role in creating a fair, safe, and inclusive work environment. This role includes avoiding discrimination, providing reasonable accommodation, preventing sexual harassment, and valuing diversity. Avoiding discrimination. One of the most fundamental responsibilities is avoiding discrimination. Avoiding discrimination requires employers to effectively design fair, job-related, and consistently applied employment practices. Discrimination may occur intentionally or unintentionally, so employers must understand both disparate treatment. Intentionally treats employees differently based on protected characteristics, and disparate impact. Natural employment practices disproportionately affect protected groups. Using valid job criteria, clear policies, manager training, and accurate records help reduce legal risk and promotes fairness and trust. Providing reasonable accommodation. Equal treatment alone, however, doesn't address every employee's needs. For this reason, employers are also responsible for providing reasonable accommodation. Providing reasonable accommodation is a key employer responsibility under Equal Employment Opportunity laws, especially the Americans with Disabilities Act (ADA). The ADA requires employers to take affirmative steps to help qualified individuals with disabilities perform essential job functions, as long as the accommodation doesn't cause undue hardship. In most cases, accommodations are low-cost and help improve inclusion, productivity, and employee retention. Preventing sexual harassment. Preventing sexual harassment is an important employer's responsibility under Equal Employment Opportunity laws. Sexual harassment is a form of sex discrimination and can involve quid pro quo, something for something behavior, or a hostile work environment. Employers can reduce legal risk and promote a respectful workplace by using our clear policies, training employees, and responding quickly to complaints. Valuing diversity. Beyond basic compliance, organizations are expected to build a more inclusive approach. Valuing diversity goes beyond legal compliance and focuses on creating a workplace that respects individual differences. It is a strategic approach that can improve performance, innovation, and employee satisfaction by promoting inclusion and respect. Organizations can strengthen teamwork and better serve diverse customers and communities. Occupational Safety and Health Act, or OSHA. Workplace safety in the United States is regulated by the OSHA, which requires employers to maintain safe working conditions and follow national safety standards. The Act is enforced by the OSHA, which conducts inspections and take action to correct unsafe conditions. Employers must identify and control hazards, while employees have the right to, to, to a safe workplace and the responsibility to follow safety rules. Overall, the Act strengthens workplace safety by making hazard prevention and shared responsibility between employers and employees. Employer-sponsored safety and health programs. Beyond basic rules by the government, many organizations choose to take an extra step by creating employer-sponsored safety and health programs. These programs are voluntary, which means they are not only about meeting legal requirements, but about showing real commitment to employee safety and well-being. Through this program, organizations aim to reduce workplace injuries and illnesses, while also helping employees feel safer and more supported at work. Employee-sponsored safety and health programs usually focus on prevention rather than reaction. This means organizations try to identify risks early, provide safety training, and encourage employees to take part in safety activities before accidents happen. Employees' involvement is very important in this program because safety becomes more effective when everyone feels responsible, not only management. While when employees understand safety procedures and feel encouraged to follow them, the overall work environment becomes healthier and more positive. As a result, well-designed safety and health programs can reduce accidents, lower absence for work, decrease health-related costs, and enforce employee morale. In the long term, this program benefits both employees and organizations by creating a safer, more productive workplace. Identifying and communicating job hazards. A strong safety and health program always begins with identifying and communicating job hazards. Before accident can be prevented, organizations must first understand what kind of risks exist in the workplace. This risk can come from many sources, such as physical hazard like machinery and noise, chemical exposure, biological risk, and ergonomic problems caused by poor work position. To identify this hazard, organizations often use tools such as workplace inspection, job hazard analysis, and review of accident or injury records. However, identifying hazards alone is not enough if employees are not aware of them. This is why clear communication is a critical part of workplace safety. Through safety training, written procedures, and regular briefing, employees can learn what hazards exist in their jobs and how to hazard may affect them. Clear communication also helps employees understand how to prevent injuries and what action to take when they face unsafe conditions. When employees are informed and aware of workplace risks, they are more prepared to act safely and responsibly. As a result, identifying and communicating job hazards play a key role in reducing accidents and creating a safe work environment. Reinforcing safe practices. Identifying workplace hazard is important, but it will not be effective if safe behavior is not consistently reinforced. For this reason, reinforcing safe practices is a key part of any successful safety and health program. Management has an important role in making sure safety rules are followed on a daily basis. This role includes giving clear guidance, providing regular feedback, and reminding employees about safety expectations. Positive reinforcement is also important. When employees when employees are recognized for following safety procedures, they are more likely to continue practicing safe behavior. In some situations, corrective actions are needed when unsafe behavior occurs. These actions are not meant to punish employees, but to correct behavior and prevent future accidents. When safety expectations are consistently applied, employees begin to see safety as a part of their daily responsibilities. Over time, safe practices become routine and naturally integrate into how work is done. As a result, reinforcing safe practices help create a culture where safety is taken as seriously by everyone in the organization. Promoting safety internationally. Promoting workplace safety becomes more challenging when organizations operate across different countries. This is because each country has its own labor laws, safety regulation, and level of enforcement. In addition, cultural attitudes toward safety can also differ from one place to another. In some countries, safety rules may be strictly followed, while in others, safety may not always be treated as a top priority. Because of these differences, multinational organizations cannot rely only on local regulation. Instead, many organizations choose to apply consistent internally safety standards across all their global operations. These internal standards help ensure that employees receive the same level of protection regardless of where they work. To support these standards, organizations invest in safety training, clear communication, and strong leadership commitment. Leaders play an important role by setting expectations and showing that safety is a shared responsibility. By promoting safety consistently around the world, organizations can protect employees, reduce risk, and maintain a positive global reputation. In conclusion, workplace safety and health are not only legal duties, but also important priorities for organizations. Through employer-sponsored safety programs, companies can move beyond basic rules by identifying hazards, supporting safe behavior, and promoting safety at all levels. When safety becomes a part of daily work, employees feel protected and valued, which leads to better performance and long-term success.